Good morning, everyone. Happy Sunday. I'm going to give people a few minutes to tune in. And I am here all by myself this morning. Nazarina's on vacation this weekend, and I had a couple of people lined up to come on and chat, but they had other things going on, so it's just going to be me this morning. So I'll give everybody a couple of minutes, but this whole week I've been in a mediation training. We have to, as mediators and as lawyers, we have to do continuing education. So this week I was in my mediation training, and I thought I would use today to talk a little bit about the mediation process. It was interesting because the mediation training really is for newer mediators, people who are initially getting licensed as a mediator or certified as a mediator. But those of us who have been mediating a long time have to do these renewals. So we go in for a shorter period of the class, and the people who are newer have to take a longer class. So it was interesting yesterday to be in this mediation training with newer mediators who haven't started practicing yet, and I realized how confused even they were about how mediation works and the process and what to expect and all of those kinds of details. So I thought that since I'm here by myself this morning, I would just spend a little bit of time talking about mediation. And for those of you that are tuning in, if you have questions about mediation, please feel free to ask, because like I said, I am here by myself today. So, hey Dana, thanks for joining. I saw you liking and following some of our stuff, so I appreciate that. So one of the things that I was talking about yesterday to the group of newer mediators, which I thought is helpful for people going through the process to know, is just sort of what to expect about the process of mediation. Now, every mediator handles things a little bit differently. So I'm telling you guys how I do it as a mediator and how I see most mediators do it in family law, but it could vary a little bit from one person to another. To begin with, really post-COVID, all mediations are virtual. There are a few lawyers throughout the state who are kind of adamant about having in-person mediations. I do not do in-person mediations. Even when my clients want in-person mediations, I convince them that it's really not a good idea, because the reality is that since we've converted over to virtual mediations, which for my office we were doing even before the pandemic, I've discovered that really virtual mediating is so much better and more helpful than doing it in person and live. And the main reasons for that are, it's really easy for me to share my screen with you. It's really easy for me to get the mediator's attention if they're in the other room. When we were in person, it's kind of hard to share information, to share charts, summaries, show child support guidelines on my screen, and those kinds of things. So typically with family mediation, everybody's going to show up on a Zoom, and maybe you're going to all be in the same Zoom room together for a few minutes for the mediator to do their opening, because all mediators have to do an opening that explains that they're not a judge, that the process is confidential and voluntary, that the parties have the ability to negotiate without thinking that what they're talking about is going to go in front of the judge later, or the information's going to get out of mediation. So the mediator is going to give you all of those details about the process. They're required to. And they're also going to talk about the fees. So that was another interesting thing that came up in mediation yesterday, was a discussion about the fees of the mediator. So there's a lot of different ways that the mediation fees come about. So there's court-subsidized mediation in almost every county in Florida. And if you have certain income requirements, then you may qualify for court-subsidized mediation. Court-subsidized mediation may be $60 for the whole mediation. It may be $60 an hour. It depends on your finances, and it depends on the court's order and your circuit that you're in and what processes they have in place. However, in my office, we hardly ever use the subsidized mediation. I may not be the popular person here, but my opinion is that the mediators that you get through court-subsidized mediation are not the best. It's not as likely for you to settle, number one. And number two, the time frames that they give you for the court subsidized mediation are super short, and they are a hard cutoff. So if it's 3 hours and you are at 2 hours and 59 minutes and you're super close to getting it done, it's cut off. And the problem with those kinds of things is that mediation really is this process that sort of like expands the parties' ability to negotiate. We stretch and stretch and stretch to the limits of where everybody is comfortable. And if you walk out of mediation and you haven't finished, you haven't reduced all of that to writing, when you leave, a lot of times that rubber band pulls back in, and we don't have the same thought process or negotiation, the same willingness to negotiate that we did in mediation. So I find that to be problematic. And the thing about using the court subsidized mediation is, even if you do get an excellent mediator, you don't have any choice over that. You're just going to get whatever mediator they assign to you through the court subsidized mediation process. And I don't ever want the mediator that I have to be up to chance, because as I was saying to these mediators yesterday, even about the idea of testing out a new mediator privately, I get one shot at a good, productive mediation in a lot of situations. And I want cases to settle. I don't want my families that I work with to end up in court and litigation. It's horrible for families. It's horrible for your pocketbook. It's stressful for everybody. So I want cases to settle, but I want them to settle on good terms, reasonable terms that my clients can live with. And having a good mediator is essential to getting that done. And I don't want to leave the mediator up to chance. I want to make sure that I'm picking the right mediator for your case, for you, for the other party, for the other attorney, and that we're getting as close as we can to improving our chances of success. So the other thing about private mediation is the share of the cost and the hourly rate. So private mediators range in cost, I would say, everywhere from $200 to $500 an hour. The $500 ones are rare. Most mediators are somewhere around $300 an hour, $250, $350, something along those lines in Florida. It's definitely going to depend on their skill set and the area that you're in and the complexity of the issues and all of those kinds of things. But that's an idea of what the costs are. And in terms of how those costs get shared, they typically get shared either 50-50, each party pays 50%, or pro rata, which is based on your share of the income. Sometimes you will have a situation where one party is paying all of the mediator cost, but I am always really hesitant to do that, and I'll tell you why. A good example is a mediation that I had last week where the husband was paying all of the mediation costs, and this is a story for another day because it was a doozy, but basically dad had just washed his hands of the whole thing and said, I'm walking away, have whatever you want, I'm done. She can have whatever she wants. And even after saying she can have everything she wants, the mediation lasted for 8 hours. And one of the reasons that that's going to happen is because the wife didn't have to pay anything. She was sitting there billing time against the husband, contemplating whether she wants to get everything that she asked for. And that is a perfect example of why it's not a good idea for somebody to not have any skin in the game or dog in the fight or whatever kind of metaphor you want to use. We want people to have some financial responsibility so that they don't misuse the process of mediation. Now, what does mediation actually look like when you're there? So usually the mediator is going to split you into 2 different rooms. You'll be in a room with your attorney, the other. If people don't have attorneys, then they will be in the room on their own, and the mediator is going to bounce back and forth between the 2 rooms. The mediator typically starts with the petitioner and then moves over to the respondent. The mediator is going to gather information and start piecing together what the issues are and what possible solutions we might have to the outstanding issues. And they're going to bounce back and forth, kind of piecemealing together an agreement over time. You're going to have a lot of time by yourself with your attorney that day. So there's going to be a lot of time to talk about the details, your thoughts, your goals, all of that stuff. But you do want to make sure that you're preparing before mediation. You want to make sure you've talked to your attorney, you have all the financial information that you need, you've provided everything that you need, and that you and your attorney are generally on the same page about what your goals are. But it is a little difficult to talk about the specific outcomes of mediation before you get there, because the reality is the reason you're there is to sort of talk through these issues and get an idea of what the other person is willing to do, what the other person wants, what you're willing to do, what you want, and to sort of finesse that into some kind of an agreement. If you do reach an agreement at mediation, it typically is typed up that same day, either by the mediator or one of the attorneys. You're going to have the opportunity to review it, make changes to it, edits to it, and then when it's in a place that everybody is okay with, we typically sign them electronically at this point. And the good news is that if you go to mediation and you settle all of the issues at mediation, you're pretty much done with your case. In some instances, you don't even have to go for a final hearing. We're just able to send everything in. Now, if you go to mediation and you settle some of the issues but not all of the issues, which you can do at your option, and there's strategy involved in whether you want to do that you should talk to your attorney about. But if you do decide that you're going to settle on some of the issues and not all of them, then the part you agreed to gets typed up. It's a partial agreement. And the issues that you didn't agree to, those go in front of the court. Now, that is sometimes a great option because it can really reduce your litigation costs and keep us from arguing about things that we're on the same page about, and let us just argue about the things that we really have differences of opinions about. So a partial settlement agreement is an option. And then the final thing is that you could just be there and not be able to reach an agreement, and then what's called an impasse is reached, and the mediator files an impasse report. That impasse report is important because mediation is required in family law cases where there are children involved in Florida, unless the court has excused you from the requirement of mediation, which very rarely happens. So you want that impasse report because that's your ticket to get into litigation with most judges. More and more throughout the state, judges are requiring us to mediate before we have evidentiary hearings. In some circuits, they only require it for you to have a final hearing or a trial. In other circuits, they even require it for you to have a temporary relief hearing. So that's kind of a summary and a synopsis. Finally, at mediation, you're going to need to work through all of the required issues in your case, but the great thing about mediation is we can talk about anything. We're not limited to just what you pled for in your petition. We can be creative with our solutions. We don't have to keep ourselves in the confines of what the statutes or the law says. We can really think about what's great for your family, what's going to work for your family, and what pieces we need to move to get everybody to an agreement. So I'm a very big fan of mediation. I find that with mediation, you should go early as possible, and sometimes multiple times, because it's a great use of your money. It is probably the best investment of money, given that you go in prepared and you have a good mediator lined up. And you are working with an attorney who's good at problem solving and resolution of cases. If you have those factors in place, then I think mediation is probably the best use of your money in a family court proceeding, because many, many, many times it's all we need to be able to fully resolve the whole thing. All right, guys, since it's just me this morning, I'm not just going to keep talking to myself forever. I appreciate everybody joining in, and we will see you guys next Sunday.